Okay, this is our last class, so I'll go over a couple of housekeeping matters, and then we'll go through copyrights, and then I'll briefly explain a little bit more of what I talked about in my email with the sample agreement. So I have received a couple of papers and have responded to them. If for some reason you have submitted a paper and you haven't heard from me, shoot me an email, because the amount of emails that I get about 300 to 400 a day. A lot of it's junk, and so hopefully it didn't get caught in a spam filter or whatever. But so if you sent a paper and you did not hear from me by last night, remind me and I'll look at it again. If you are planning on doing a paper, because there's a couple of people I did respond to in that, you can get it into me whenever you want, and I'll take a look and get you guys responses as quickly as possible. And then obviously, what the intent will be is, since we're going to have the exam next Friday, I will grade those over the weekend, and I will send everybody out your final exam and your final grade. You will have that by Monday morning. And if anybody wants to write up for that, I have to find out what date I need to submit grades, but I think it's like May 12th or something. So you guys will have time. If you want to do another paper, I will review it and grade that up, and so you guys can bump your grade up if you need to do that or desire to do that. Obviously, the $1,000 prize is based just on raw scores, so it's not on writing papers. So, and I think there were a couple people that were right at the same score after the midterm, but I think there's a number of people that are still eligible for that, depending on how your grade is. The midterm is 30 to 35 questions. I'll have a couple of extra credits, so whether you get them wrong or not, it doesn't matter. But if you get them right, it will help your raw score for that. So those will be the last couple questions. They'll be identified. I can't remember if I'm going to have 2 or 3 this year. I got to go back and look at what I've done in the past. But they'll be identified. They'll be the last 2 or 3 questions of the exam. Same format as last time, multiple choice, some true and false. And then, as you would expect, the bulk of the exam, of the 35, probably 18 to 20 of them are going to relate to the A201. The lectures from that will be posted this afternoon. I talked to my IT guy because we had some issues. I couldn't find my recorder for a while, so those will be all posted by this afternoon for all the lectures, including today's. So anything you need to go back and look at will be available for you guys to take a listen to. And because we were able to because I did cover claims last week in the beginning of last week's lectures, so Article 15 of the A201, there may be a question or two on that on the exam. So there was one year, 4 or 5 years ago, where I didn't get to Article 15, so we didn't have it on the exam, but since we had some extra time this semester, it will be on. Anybody have any questions? Okay. We're going to zip through copyrights. I save it for the end. I talk about it through all the semester, but I save it for the end, not because I want because it's minimized. In fact, I think it's actually really important. But it's very different. It's not used much in your world, at least on the legal side of it. I have had only a few copyright cases, copyright infringement cases. I've had a number of times where the owner has requested to go in and potentially file a copyright infringement action. The problem with the copyright infringement claims is it's a very expensive bit of litigation, and I'll talk a little bit about that. And then, like I said, we'll zip through the sample agreement. You guys will be out of here. So, okay. So the Copyright Act is an act that was put together. It's actually starts in the Constitution. Patents and copyrights are in the U.S. Constitution, and it was going back when the days is when they were putting together the Constitution. People needed to own what they created and what they invented. And so the founders of our country, when they put together the Constitution, said they have to have this right. And so it then has become statutory, and so you have 3 different sections. You have what's a patent, an intellectual property, you have a trademark, and you have copyrights. Now, by and large, the only thing that's going to be applicable to the design world is going to be copyrights. But on a small thing, I'm going to talk a little bit about patents and trademarks just so you guys can understand the difference. All of this is called intellectual property. So there's 3 types of properties that the law recognizes and then uses, and how the lawyers, whether they're specializing or what they litigate and everything else. There's real property, that's land. There's personal property, that's what you own, your car, your house. something that is most of the time is portable, but sometimes it's not. Your house is actually, parts of your house inside of it is personal property, but as the house connects to the land, they call that real property. And then there's intellectual property. Intellectual property is where we're talking about here, patents and trademarks and copyrights, because you can own something, but you can't really hold a trademark. I mean, you can hold the picture of a Coca-Cola logo, but that doesn't mean you own it. It's the only ownership conceptually is in your mind or on paper. So that's why they call it intellectual property. It's not personal. It's not real. It's intellectual property. When I first got out of law school, due to the market and the economy and a whole lot of other things, my first 2 years I practiced only intellectual property. And it's a very difficult concept to grasp of what you're fighting for because you don't really have something tangible in your hands. So when I talk in this lecture, I try to break down just a little bit. So a patent is intellectual property that is an invention or the ownership of something, of a function. There are things called design patents, and that's a little bit different than a copyright, but it's a functional machine or equipment or a computer program. It's something that actually acts and that you have invented it. And when you have a patentable product, you have to break it down and distill it into very specific and detailed descriptions. So when someone gets the patent and they read it, the theory is you should be able to build that product from the patent. The reason why they do it that way is because a lot of people want to make something, you've heard of knockoffs and something a little bit different. And so if you have a patent, one of the patents I worked on was for the slip and slide. You all remember the slip and slide? You run and you slide. That thing has been around for years, 75 years or something like that. But there was a patent that we wrote on it which had to do with how the water spraying system, and they had this little spinning thing and everything else. So it wasn't the original just long sheet of vinyl that you put a hose connected to with some holes in it and you slid down. It had this connection with this plastic piece that spun and how the water in. And so the patent described how the hose connected to the certain area and how the machine spun and how the water came out. And you use different descriptive terms. It's not like a specification that you might write when you're doing a design, but it works similar to that. I worked on a patent for a race car set, like the little slot cars when you were little. And what we patented on that, because slot cars have been around forever, so they're not patentable anymore. Once they have a certain length of time, you can own a patent. What was about this was, as the car went around the corner, there were little pieces of flint on the axles, and the guardrails had sandpaper on it, so it sparked. So we had a patent in the cars that went around the corner that sparked. I worked on medical instruments, dental instruments, a whole bunch of things. The patent, when you get granted a patent, and what you have to show to the United States Patent Office is this is a new invention, that no one has ever done that before. And when the Patent Office gets a patent a patent application, they're going to go through and they're going to compare it to every other patent that's been on file. So every single patent that exists out there is held by the United States government, and they're going to go through and do comparisons, and you have to argue why yours is new and different. Once you're granted a patent, you hold it for 17 years. That's also constitutional. And then after the 17 years, it goes away, and it becomes available for free market for everybody in the public. So one of the things that I take every morning is Allegra, because I have allergies. Allegra, that they had a patent on Allegra, the drug, because the drug itself has a chemical process when you put it in, and all these drugs are patented and everything else. And that drug that was only allowed to be patented for 17 years. At the end of that lifespan, it became a generic. Now it's phenylphthalein or something like that. And now you have generic drugs. So when you hear about generic drugs, what they're really saying is the owner of that patent, the chemical company that invented it, that patent has expired, and now they don't have rights over it, and everybody else can make it. They can take that invention and what is described in the patent, and they can make it from that. So back to going to the founders of the government, they said, we're going to have these patents. You're going to allow ownership, but we're not going to allow you to keep it indefinitely, forever. So that's patents. And there's medical, any invention you could ever think about. The other thing that a drug company might do, or other companies that have, they may take that drug and they may change one teeny tiny little element of it, and then they can have a brand new patent, and it's a derivative of it. So sometimes you'll see drugs that have been on the market for many, many years, and they're sold under one brand name. It's because they were able to tweak just a little bit and not extend, but get a new patent. That's just something that, that the scientists work on, and then they have to submit, and they have to show why it's not the original and it's a new invention. Okay. Trademarks. Trademarks is more often than not is going to be a name of something, or it can be the style, like the Nike swoosh is trademark. The name Nike is trademark. Trademarks you can hold indefinitely, as long as you continue to pay your fees to the federal government to keep it on the register. And I think it's every 5 or 7 years, I'm not sure which, you have to re-up your fee. You also have to show that it's in use. So trademark also is a unique design or name that has been put out there. But the interesting thing about trademarks is trademarks are also split up into different categories. So you may have machinery, and you have the exact same name and the exact same logo as something in foodstuffs. And they may be by two different owners. And so the trademark office recognizes that in the public marketplace, they have all these different types of categories, fabrics and clothing and, like I said, machinery, equipment, different types of categories, and you can get different trademarks in those things. Like I said, you can keep a trademark going for as long as you keep it alive. The story I like to tell, although it goes back many, many years, but it's applicable here in Chicago, is obviously the Chicago Bulls was the first professional sports team to have 3 championships in a row. They did it twice. They three-peated twice with Michael Jordan. And the name three-peat was actually owned by Pat Riley, who was the coach of the Los Angeles Lakers. Because after the Los Angeles Lakers won their second championship, people started shouting out three-peat for the next year, and Pat Riley was a smart enough businessman that he went in and he got a trademark for the word three-peat for sports. And then they didn't win. And then a number of years later, the Bulls came in, and the Bulls won, and they got a three-peat. And when you own a trademark, or when you own a patent, or when you own a copyright, if someone wants to use that piece of intellectual property, they pay you royalties. So there was a certain irony that Pat Riley made millions off of the word three-peat because of the Chicago Bulls. Because anytime somebody put a T-shirt out that said three-peat, that was a licensed trademark associated with sports, and they were obligated to pay a license fee to Pat Riley. Now, there are people that infringe, if they knock it off, they go and they try to take that, and then it's up to the owner of the trademark, or patent or copyright, to file a lawsuit to actually collect on their licenses or to stop them. And that's a whole big legal process, and again, that's where expense comes in, why you don't see a lot of copyright cases in the architectural world. Another example of a copyright or a trademark that had lost, one of the things is I said you have to use that and you have to protect it. If you don't protect it and you don't use it, you lose the rights to it. One of the ones that was out there that actually lost much of its luster was Harley Davidson. Harley Davidson had branded and had put its name and that logo, that shield of Harley Davidson, on everything. It wasn't associated necessarily with just motorcycles and motorcycle apparel and those types of things. I actually, years and years ago when I was in college, I owned a Harley Davidson TV, which was kind of cool because I never was going to ride a motorcycle or afford a Harley, but I owned a Harley. And it lost a lot of its weight in the marketplace. So Harley Davidson went in, and the first thing they did, they retooled their marketing department, and they went in and they eliminated all of their licenses for things that were not associated with their true brand, which was the motorcycle. And Harley Davidson almost went bankrupt because people kind of like, who cares? Why is this such a luster? Why is this? Who cares? There's all these different types of motorcycles. And part of that business plan was to say, let's go back to our roots. So they eliminated things like my television and other things, and they now focus on Harley Davidson. Harley Davidson now is a very, very strong brand because of what they did. And so you can actually recapture it. They never lost it because they were always using it and they paid their fee, but they lost the weight of it and how much it is valued. And so now when you want to get a Harley Davidson license, not that they're going to put it on TV, but if you want to get an association with them, the value of that license fee that they pay is much higher than it was many, many years before. Another big example, aspirin. We all know what aspirin is, right? In the United Kingdom, aspirin is a trademark. There is only one brand of aspirin. All the rest of it is the generic name. And that's because aspirin, when it was used in England, it had been was the brand name first before it was introduced in the United States, was in England, and they kept control over their trademark in England, in the UK, and kept it as a strong name. When it came to the United States, people started manufacturing. There's Bayer aspirin, there's all these different types of aspirin, and it became generic, and now we all think of aspirin as aspirin, because in the United States it has no trademark value. There is no trademark because it's become essentially the generic, whereas in Europe, or in the UK, it actually is a trademark name. Last thing on trademarks, and this applies to all of them, the law is going to be country specific. So when Nike applies for a trademark, or when Apple does, or any of these other people that have a trademark, they have to apply in different countries. And depending on whether that invention is being used in that country, you may be able to get a patent or a trademark or a patent or trademark in one country, but not in the other, because someone has already applied for it. And you get into issues, and this is all part of the UK and the Brexit thing and everything else. There's a whole issue on intellectual property issues that are filtered into that because of who owns what in that marketplace. But each time you have a name, just because you have a brand you have in the United States, doesn't mean they can't rip you off entirely across the rest of the globe unless you go out and protect yourself. So that's patents and trademarks. Copyrights, which is most important for here, again, is the copyright is an intellectual property that is the embodiment of the idea, and it comes out of, as I said up here, the U.S. Copyright Act. And then obviously there's different foreign equivalents. The U.S. Copyright Act, for years and years, it talks about it must be the original expression of an idea. It can't be a copyright in the idea. And many, many years of how it, and it's always applied federally. There are different states that have some intellectual property law. There's going to be trade statutes for state by state. But by and large, copyright law is going to be federally enforced. So if you have a copyright infringement action, you're going to be in federal courts. That's the first reason why it's more expensive. Going to litigate in federal courts is generally more expensive than litigating in state courts. I don't know if there's a reason why, but that's what it kind of turns out. If you're in a federal court action, you're going to have to, the case is going to be a larger value, it's going to cost more money traditionally. Not to say that state court cases don't cost a lot of money too, but it has to do with a lot of the process and procedure they have to go through. As I said up here, the only thing that's copyrightable is the original expression of the idea. So, for example, the first movie, Jurassic Park, was a movie based on a novel by Michael Crichton. And then obviously there's a whole bunch of other Jurassic Park 2, 3, 4, whatever from that. But the very original movie was based on a novel by Michael Crichton. The book sold well, and there's a number of Michael Crichton books out there. He was I thought, a really excellent author on kind of techie, different dramata strains and other types of books. But when the film came out, it was revolutionary, not necessarily because of the storyline, but because of the graphics. It was the first time they had things like you could see the computer animation with these dinosaurs and everything, that they actually look real. And the movie made hundreds and hundreds of millions of dollars. It was one of the biggest blockbuster sellers at the time when it came out. And a couple of years after the movie was out, this man came out and filed a copyright infringement action against Michael Crichton, and I don't know if it was Universal, Paramount, whoever put the picture out, saying that they infringed on his idea because he had written a story, and I believe he wrote it before Michael Crichton wrote his book of Jurassic Park. And that book was about an island and dinosaurs and had the same storyline, kind of, as Jurassic Park. But the courts found against him because it's not just simply that you have the idea. It has to be, what's your expression of the idea? So the courts are going to go and look at it, and they're going to say, was this book by Michael Crichton and the subsequent movie the same expression of the idea, or the same expression as this guy expressed in his book? It's not going to say, I had an idea about dinosaurs on an island and people coming there and being attacked. You can't just have that. It's, how does the story play out? What is the dialogue in that story? What are the imagery? What are all the parts that make the expression of the idea tangible? And that's all that's copyrighted. Another example is music. So when people go in and write a series of notes together, you may have a couple of notes that go in the same line and the same verse as somebody else, but if the rest of the song is different, that's not necessarily a copyright infringement. And the courts, if you start reading the cases, you start getting into where the nuances are, but it's always how you express it as opposed to the actual idea. And that's all that's copyright over. You can't just say, oh, I had this idea of this cool painting, so I get a copyright on that idea. No, it's only on the actual painting. Now, for about 75 years or so when the Copyright Act was in place, there was nothing specific to architecture, nothing specific to drawings. What you had to do to get a copyright is you had to submit your copyright application to the U.S. Copyright Office, and you would send in a copy of your drawings, the actual physical drawings, a copy of it. This is long before electronic age and everything else. You literally had to print it out, roll it up, and send it into the Copyright Office. And that got copyrighted just like a book would, or just like a painting would, or a photograph would. The actual physical, tangible piece of the drawings was copyrighted. And then what happened is, and where the lawsuits came and where the change in 1990, they had the U.S. Architectural Copyright Act, they amended the Copyright Act to include specifics as to the architecture, is what happened was in the residential area, people would go out and principally in subdivision developments. So you get a developer, they buy a tract of land, they put a bunch of roads in, and they put out your 5 different types of houses. There's the colonial, the Georgian, the ranch, or whatever it is. And as you drive through the suburb, you see 5 different types of houses, some with different shutters, some with different colors, but there's this general feel of what these houses are, and they're nice designs. And so when you want to buy in the subdivision, you're like, okay, I like this colonial better than this colonial, but they're all based on the same idea. They're all based on the same original design. And those developers who hired architects would submit those 5 or additional number of house designs, and they would get a copyright on that. And the copyright had the piece of paper. And one of the things that we go into, and I'll talk about in a couple of slides, is in order to be infringing of the copyright, you have to have access to the original copyright. And what people would do in the residential area, they would go out, they would see the house, they would take pictures of the house, they would walk through and sketch the floor plan on their own, and they'd go back and they'd build those 5 houses in another subdivision, so it would be a competing developer, maybe the next subdivision over, maybe 2 towns over, and they could build the exact same 5 houses and not be caught for infringement. Because the house, when it was built under the original Copyright Act before 1990, was not copyrightable. The only thing that was copyrighted were the actual drawings and specifications, not the actual construction of the house. So they came back in, and the major change of the U.S. Architectural Copyright Act was to say that the original expression of that idea can be both the tangible paper and the physical construction of that. It was a big change because you were able to now protect designs, and you were able to protect people as far as what they thought of their original idea, and the people wouldn't be in competition basically with themselves because somebody ripped off their drawings. Okay, so that's just generally overall how we got to the U.S. Architectural Copyright Act in 1990, how it will be applied. We'll talk a little bit more about that in some later slides, and where the world of intellectual property sits overall. So, next thing we have up here is classifications of ownership. So, with the copyright or any intellectual property, the first thing that the courts will look at is who is the owner of that? Who owns that property? So the default, as far as you guys are, where we start, is the architect owns the drawings. If the contract has no language about intellectual property or copyrights, the owner of the copyright, the intellectual property in those drawings, is the architect. That's the default. Now, In the AIA documents, you guys may remember in the B101, it's also in Article 7, and then there's sprinkled throughout Article 4 in the A201 and a couple other provisions. They use this term, and there's sprinkled throughout Article 4 in the A201 and a couple other provisions. They use this term, and there's